Today on Bench Briefs, we're looking at a recent Supreme Court of Canada decision that dives into the important issue of police searches and our constitutional rights. In R.V. McColman, the court tackled the question of how evidence obtained by the police must meet constitutional standards to be admissible in court. This case reminds us why the rules around search and seizure protect not just accused individuals, but the integrity of our justice system as a whole. So, what happened in this case? McColman was charged with criminal offenses following a police investigation. The focus wasn't just on the charges themselves, but on how the police gathered the evidence that led to those charges. Specifically, the way the police conducted their search and seizure raised serious questions about whether McColman's rights under the Canadian Charter of Rights and Freedoms were respected. The Charter, as you might know, guarantees everyone in Canada certain protections against unreasonable search and seizure. These protections help ensure that police investigations are fair and respect individual privacy. In McColman's case, the police had conducted a search and seized evidence that became central to the prosecution. But McColman argued that the way this evidence was obtained violated his charter rights. This meant the court had to carefully look at the circumstances of the search. Was there proper legal authority? Were the police procedures followed correctly? And importantly, did the police conduct amount to an unreasonable search or seizure under the charter? The Supreme Court's role was to decide whether the evidence should be excluded because it was obtained in violation of constitutional rights. This is a big deal because if evidence is gathered improperly, it can't be used in court. This rule helps deter police misconduct and protects the fairness of trials. So what did the court have to consider? First, was the search lawful? This involves looking at whether the police had a valid warrant or if an exception to the warrant requirement applied. Then, the court examined whether the police followed the rules laid out in the charter and related laws. If the police overstepped, the court had to decide if that breach was serious enough to exclude the evidence. Excluding evidence is a remedy that balances the need to uphold rights with society's interest in prosecuting crime. While the court's full reasoning is detailed and nuanced, the key takeaway is that the Supreme Court reaffirmed the importance of strict compliance with constitutional protections during police investigations. Evidence obtained through an unlawful search can't simply be swept under the rug. Instead, courts must carefully scrutinize police conduct to ensure that rights are upheld and that justice is done fairly. Why does this case matter beyond McColman himself? It sets an important precedent for how Canadian courts handle similar situations going forward. Police officers and lawyers across the country will be paying attention to this ruling because it clarifies the standards police must meet when conducting searches. For everyday Canadians, the decision reinforces that constitutional rights are not just words on paper. They have real power to protect privacy and prevent abuse. In the bigger picture, cases like R.V. McColman highlight the ongoing balancing act in criminal law, ensuring effective law enforcement while safeguarding individual freedoms. It's a reminder that the justice system depends on both respecting rights and pursuing truth. When courts enforce these principles, they help maintain public confidence in the fairness and legitimacy of our legal system. Thanks for listening to Bench Briefs. Join us next time for another deep dive into a case that shapes the law and affects us all.